The Supreme Court this morning delivered several welcomed rulings, including one for parents as well as for religious freedom. The case Mahmoud v. Taylor. In that case, parents now from various religious backgrounds, well, they all banded together. They were challenging the Montgomery County Public Schools elementary story hours. You may recall we've reported on it, but that story hour promoted books on things like pride parades, gender transitions, and various LGBT themes. Well, today, in a 6-3 ruling, the Supreme Court justices backed the parents who took a stand trying to protect their children from these radical agendas. So, what was the reason for the ruling? And probably more important, what might be the impact of all of this? Well, here to discuss this case is Daniel Schmid. He's a constitutional attorney and Associate Vice President of Legal Affairs with Liberty Counsel. And by the way, Liberty Counsel filed an amicus brief in this case. Daniel, welcome back to Washington Watch. Great to have you, and great news today.
It was good news, and thank you for having me, Jody.
Okay, so let's begin. Just walk us through the ruling from this case. What actually did the Supreme Court say?
Well, what they said is that just because you drop your child off at a public school doesn't mean you forfeit the right to direct their religious upbringing. We decided that issue about 53 years ago in Wisconsin versus Yoder, but it has come back up in the curriculum-based education for elementary school children, and the question being whether you could have a religious opt-out to curriculums that parents find religiously objectionable. The Supreme Court rightly held today that of course they do. The First Amendment affords parents the right to direct the religious upbringing of their children, and they don't surrender that at the schoolhouse gate.
So what was the bottom line of this case? In other words, was this a case about parental rights, or was it a case about religious freedom and the right to parents to pass the baton of that religious faith on to their children? How would you describe what ultimately this case was all about?
Well, it's based on the free exercise clause of the First Amendment, but what I would say is, in this regard, the free exercise of religion and the fundamental rights of parents are inextricably intertwined when it comes to this. So for many parents, the right to raise their children according to the dictates of their faith requires that they prevent them from hearing some of the obscene materials that were read to elementary school children, and require that they don't promote what the Bible says and what other religious faiths of the parents in this case say are sin and are forbidden. The teachers were teaching curriculum that violates what the parents were teaching at home. They have the free exercise right and the parental right, both of which are constitutionally grounded, to opt their children out of that curriculum. The Maryland County Public Schools tried to say you can't have an opt-out. They prohibited it. And oh, by the way, we won't even provide you notice when we're going to read these stories to your children. The Supreme Court this morning said you can't do that.
Okay, yeah, so let's go down that path, because I think this is fascinating. Everything you just said is just so much common sense. I mean, to me, it sounds kind of amazing that we're even having this kind of case go all the way to the Supreme Court. But what was the argument from the other side? Why in the world did they believe that parents should not be allowed to take their kids out of a class that teaches this type of stuff?
This is the most comical part of it all, if you ask me, Jody, and Justice Alito does a good job dissecting it. What the Montgomery County Public Schools said was, well, we've created this curriculum that's pretty obscene, that a lot of people object to. And the problem that it has begat is that there are too many parents who object to their 3 and 4 and 5-year-olds reading about Pride Puppy and some of the other obscene materials, that it becomes unworkable for us. And what Justice Alito says is you don't get to create a problem and then deprive people of constitutional rights because the problem's too big. But that was their defense. This is unworkable to opt all of these parents out and the students out on the basis of religious beliefs. That was essentially their entire argument for why they could prohibit an opt-out.
Wow. All right, so as you just mentioned, I mean, this has obviously been a closely watched case for religious freedom advocates, at least. So, big term, 30,000 foot view. What does this ruling mean for religious freedom?
I think it has major implications for religious freedom, not the least of which is there are millions of parents who enjoy the public benefit of the public education system. We could debate the merits of that all day long. Have me back and we'll have a different discussion about that. But for purposes of today, those who take their children to a public education institution don't surrender their First Amendment rights when they drop them off. If the school and a radical school board and radical teachers want to impose a curriculum that violates the religious beliefs of the parents, they have the right to say no, and they have the right to opt their children out. The First Amendment demands that, common sense demands that, and thankfully the Supreme Court today demanded that.
Less than a minute left, and I wish we had more because there's so much I'd like to get into. But the Supreme Court this morning also upheld a Texas law requiring age verification for access to internet porn sites. Real quickly, your thoughts on that decision?
I think that's pretty common sense, Jody. We have age restriction and age verification requirements for all manner of things: driver's licenses, purchasing various items in the store, registering to vote, obtaining access to obscene materials that has become rampant. The court notes today has become rampant because of the proliferation of the internet and cell phones and websites that are all over the place. Texas said we're going to require you to have an age verification requirement. The Supreme Court says the First Amendment doesn't prohibit that. We've allowed that for years, and they allowed it again today.
Daniel Schmid, Associate Vice President of Legal Affairs at Liberty Counsel, thank you so much. Great news coming out of the Supreme Court today. Appreciate you
Thank you,
bringing it to us.